screen, and we'll go through them at the end of the presentation so we address any of your concerns or additional questions that you might have. And so with that, I'm going to turn it over to Fraternal Law to talk about Title IX today.
Wonderful. Well, thank you. We're pleased as always to partner with VonLehman to do these presentations, and we're grateful to get the opportunity to connect with each of you. My name is Micah Cameras. I'm going to be joined by my colleagues Sean Callan and Alana Lindner, talking about Title IX and these new regulations that you've probably heard might be coming for years now, which have officially been announced and go into effect this week. So that's the topic for today. We're also going to, at the end, try to be able to take questions about this or other topics people may want to talk about. And we've got a few other kind of just hot topics we'll raise as well. So that's the plan for the next little while, and we'll start working through the presentation. If we can move to the next slide, please. So the question here, we're going to try to start with the who, what, when, where, why of Title IX, just the basics of these new regulations. So the who is this applies to all institutions of higher education that receive federal funding, which is almost every institution of higher education in the country. There are several, they're mostly small religious-based groups that don't receive federal funding, which includes things like federal student loan aid. So there are a very small number of colleges, maybe one or two, that have college Greek life. But other than that, any institution, public or private, this applies to them. And the next slide is when. It's been announced for quite a while that these regulations were coming. Honestly, we've kind of been waiting years for them. But they were announced on May 6, 2020, that they would become effective on August 14th, which is 2 days from now, designed to be in place for the beginning of the school year. We'll talk a bit more about this later, but they were kind of announced amidst a pandemic, and they're going to go into effect during obviously a chaotic and hectic time as school starts back here. But that's the timeline on these specific regulations. So next is talking about what exactly are we talking about Title IX for these proceedings, these procedures talking about sexual harassment. So it applies to a school when the following is true. When a school has actual knowledge of sexual harassment that occurred within the school's educational program or activity against a person in the United States. So the number 2 on there is, I think, the most interesting and where we'll spend a lot of time today. Whether a school has actual knowledge of sexual harassment is usually, was there a report? But number 2 is going to be the most interesting, and that's kind of occurred within the school's educational program or activity, and what that means. Number 3, against a person in the United States, is relatively self-explanatory. So where this applies to things that occur on campus, and also in educational activities off campus, such as college-sponsored trips and events at off-campus, privately owned houses of recognized fraternities and sororities. That's the language in the actual regulation itself, recognized fraternities and sororities. It's the first time I've ever seen language in a federal regulation that draws a distinction between recognized and unrecognized groups. But this was designed, I believe, to create some type of clarity. Under previous Title IX regimes, it was unclear if 2 college students who were on vacation on spring break, unrelated to the university, if alleged sexual harassment occurred there, if Title IX would apply. So this is, I think, designed to make it a bit more narrow, that it applies to things off campus, and also on campus, and also certain things off campus. And we'll get more into the specifics of that later as well. So here's kind of the fuller text of what it says. It says, where a post-secondary institution has officially recognized a student organization, which for purposes of our discussion today, we'll say is fraternities and sororities, and sexual harassment occurs in an off-campus location not owned or controlled by the student organization, yet involving members of that recognized student organization, then the school's Title IX obligations will depend on whether the institution exercised substantial control over the respondent in the context of the harassment, or whether the circumstances may otherwise be determined to have been part of the operations of the institution. So I put this up there for a couple of reasons. If you're having a hard time following it, you're not the only one. As far as how this is interpreted, I think it's going to be fascinating to see how that plays out. Generally, while talking today about fraternities and sororities, the sexual harassment occurs at something involving on an off-campus location that involves a fraternity or sorority recognized by the university, but not specifically at their facility. And that's where this will really get to be. There are all sorts of questions of what happens at formals or at bars or at themed gatherings elsewhere, and this will be the language that ultimately is looked to decide whether or not Title IX applies in that instance. So why was this done? We've had new Title IX regulations during the previous administration. Since that time, there have been a number of federal court decisions about Title IX and the due process that students who are accused of violating Title IX are entitled to. We're going to talk a lot about the due process that these regulations institute here in just a little bit. But this specifically, in large part, was done to create closer alignment with a lot of those federal court decisions, which are binding in the areas of the country that those courts have authority over. It was designed to make clear kind of the balance of the rights between the complainant and the respondent, or the accused and alleged victim, all those types of things to create a fair balance in the process. And since these have been announced, there has been tremendous disagreement among experts about whether or not this actually creates balance or a better balance. There have been a number of lawsuits filed challenging these regulations before they go into effect. So far, no injunction has been placed on them, so they are still scheduled to go into effect 2 days from now, but these have been deeply controversial since they have been announced.
Okay, so let's talk about what the, let's talk about what the changes actually are. This is not going to be an exhaustive list by any means. There's about 2,000 pages worth of the new rule. So we're trying to just kind of highlight the most prominent points or takeaways that we think apply to the people that are in attendance today. But again, this is not an exhaustive list by any means, and I do encourage you, if you have more specific questions about things we don't cover, to still consult where appropriate to make sure you're in compliance with it. So there's both procedural changes, which I'll get into in quite a more depth here in a minute, but there's also policy changes at the university level that are being required pursuant to the final rule. So I want to start with some of those university policies. These are things that ideally universities have been actively working to figure out how to comply with during this interim period before they go into effect, because some of these things need to be ready to go basically in 2 days from now. So hopefully universities have been working on this. If not, they've got a lot of catch-up work to do. But the underlying theme, and you'll see this pop up in different ways through the different procedural changes, especially, the underlying theme that's guiding a lot of this is a presumption of non-responsibility. That means that the accused student, who I'm going to refer to as either the respondent or the accused, in contrast, we'll call the claimant or the accuser, the other party. But there needs to be a presumption throughout the entire review process up until the point that there is a final determination, a final adjudication of responsibility being determined, that the individual who's being accused has not actually done what they are said to have done. And that is to protect their rights and to make sure that the adjudication is occurring based on evidence rather than under any underlying motives or beliefs about who that person is or what his or her beliefs may be. Another major requirement of university policies, this isn't necessarily something new, but it is explicitly required now, is that the universities eliminate this so-called single investigator model. The easiest way to think about that is basically to say it's now explicitly prohibited for a university to have the prosecutor, judge, and jury all be the same person. So whoever is conducting the initial fact-finding investigation on behalf of the university cannot be involved with the actual decision making, and then likewise neither of those two people, the fact finder or the decision maker, can also be the one, if applicable, to determine the matter on appeal. So you need to have clear distinctions in roles, and there can be overlap. Again, that goes back to the ensurance of a fair and unbiased process. Again, another thing that is not necessarily new, but it is now explicit, and it kind of gives universities a little bit more leeway here, is with the standard of evidence or their burden of proof that they want to apply. In Title IX cases, they are free to choose. Universities may choose either the preponderance of the evidence standard, which is probably what's most commonly used currently, or they can apply a clear and convincing evidence standard. They can totally make up their mind there, but whichever standard they apply for one case must be consistently applied to all other cases too. So once you choose one, you're stuck with it for both student-to-student cases, employee-to-student cases, male to female. Everything needs to have the same standard, but again, they can choose which standard that is. Let me go to the next slide, please. Also at the university level, they should be creating a written list of some sort, essentially, of possible supportive measures, remedies, and sanctions. Supportive measures, the easiest way to think about these are sort of like accommodations. So things like extensions of deadlines for students' assignments, or increased security or escort services getting from their dorm to their classes or the dining hall, no contact orders, class modification, schedule modifications, and so forth. So a lot of universities are already tending to offer these types of accommodations, particularly to the claimants, the accusers. But now the final rule requires that the supportive measures, remedies, and sanctions be available to both parties. So if a formal complaint is actually filed by the complainant, then the university, upon request by either party, needs to provide supportive measures or accommodations to both the accuser and the accused. And again, this goes back to that underlying theme of presumption of non-responsibility, treating both parties at the same and not automatically discriminating or treating one person differently just because somebody else has made an allegation against them. If a formal complaint is not actually filed by the complainant, I mean, we'll use that phrase just for simplicity, but let's say somebody alleges sexual harassment or sexual assault against somebody else, but doesn't feel comfortable going through with the formal complaint process, just says, this is too much for me, I don't want to get involved with this, I want to drop it, that's fine. The university, again, upon request, is still required to provide those supportive measures or accommodations to the claimant, so regardless of whether a formal complaint is filed or not. And finally, Sean's going to go into this a little bit more, so I don't want to spend too much time on it, but universities now have a little bit more discretion in determining who actually constitutes a mandatory reporter for Title IX purposes, but we'll come back to that in a little bit here. So if we can go on to the next slide. And I want to start talking about the actual procedural changes. And the easiest way to think about this is to kind of compartmentalize it into three different phases. There's the pre-hearing phase, there's the actual hearing phase, and then there's the post-hearing or appeal phase. And so I'm going to go through these quickly. Again, this is not exhaustive. I just want to highlight some of the what we think are some of the most notable differences. Written notice is not something new. A lot of schools, again, are already providing some form of written notice of the charges. Some call it a charge letter, some call it just a notice, but whatever it is, there are now explicit requirements of what those written notices must entail. So again, universities ideally have been working on creating some form of a template right now to make sure that they're hitting all of those requirements, all of the different components. One of the components that must be included in the written notice is informing the parties that they are each entitled to an advisor of their choice. And this is a significant change. Advisors can be attorneys. I want to say that again. Advisors for Title IX cases can be attorneys. This is not necessarily applying in all student conduct cases whatsoever, but in Title IX cases, if a student, either the accused or the accuser, wants to be represented by an attorney, they are absolutely allowed to be represented by that attorney. And it's not just for the hearings, it's for all parts of the process, whether that's a pre-hearing interview or meeting. If somebody wants their attorney or advisor to be in that meeting with them, The university must allow that, and they must provide everybody advance written notice. So no longer are we just going to see students getting an email at 5 p.m. on a Monday saying, hey, you need to come meet with the Dean of Student Conduct tomorrow at 9 a.m. or else you'll face disciplinary action. There needs to be written advance notice. But going back to the advisors, they don't have to be attorneys. They could be just a family friend. They could be another student. They could be a staff or employee of the university. The parties get to choose their own advisors. Now, if somebody does decide to have an attorney as their advisor, that person is responsible for covering the costs of employing that attorney on their behalf, but they are still allowed to do it. We already kind of talked about 3, the advance notice and adequate time to prepare. And again, this needs to be written advance notice. It needs to be pretty specific, the date, time, the purpose of the meeting or the event that's going to occur. And it needs to be sent to both the parties and their advisors if they want it, their advisors involved. Evidence, both parties are fully entitled to receive both exculpatory and inculpatory evidence. And again, we've seen in the past where a lot of universities love to do this thing where they tell students, we'll let you review our evidence before the hearing, but you need to come into our office to look at it. We won't let you copy it. You can't take pictures of it. And we certainly aren't going to send a copy of it to your attorney for your convenience. Now, if the party has an advisor and requests that copies of or some form of the evidence be provided to their advisor as well, the university has an obligation to provide either a physically hard copy or an electronic copy of all the evidence to both the parties and their advisors. So again, attorneys then have a much easier way of obtaining the documents to be able to review and assist their clients to prepare for these different proceedings. And I'm not going to spend too much here, but there does need to be a formal investigation report prepared by the university. Something that's a little bit different and kind of noteworthy here is that now there's a requirement that at least 10 days, let me rephrase that. Each party must receive a copy of essentially what's a draft of the investigation report at least 10 days before the report is quote unquote finalized. And both parties will kind of have an opportunity to review the draft and submit any feedback or comments they have about that draft to the university. If any feedback is received within those 10 days by the university is required to review and, if applicable, incorporate whatever feedback is received before finalizing the report. And then once the investigation report is finalized by the university, an additional 10 days minimum is required between the time of the report being finalized and when the hearing can occur. So it gives a lot more time throughout all of this where you have to give more advance notice to both parties and their attorneys or their advisors. And you also have this 10-day, up to 20-day waiting period. It's going to be a longer process is what I imagine. We go on to the next slide and we'll talk about the procedural changes during the actual hearing. I want to preface this by saying that unless the parties mutually agree to forego a formal hearing and instead consent to an informal adjudication process, there must be a formal hearing for Title IX cases. So again, unless both parties agree to forego it, there must be a formal hearing. And as you can see here, they must be live hearings for these matters. Separate rooms, physically separate rooms, are permitted if either party requests it. And virtual participation by, let's say there's one person, whether it's a witness or somebody, especially in today's times, that just for whatever reason is not on campus or cannot physically attend in person, the university does have to make some sort of attempt to accommodate that person and allow for virtual participation. The cross-examination is also a big change here. Each party has an explicit right to cross-examine the other party and all witnesses. However, the cross-examination, the questioning itself, cannot be done by anyone other than a party's advisor. So the accused student cannot directly cross-examine his or her accuser, but could do so through his or her advisor. So that raises the question, well, what if one of the two parties can afford an attorney or has an advisor, but the other one doesn't? Is that fair? And in that situation, the university has an obligation to provide whoever is unrepresented, whoever shows up without an advisor, either one or both parties, they have to provide basically a limited advisor with no charge to the students, or to the employees involved. And so that advisor will serve in a very limited capacity solely for the purpose of conducting cross-examination. And so that person does not have to be an attorney. It could be just an employee of the university. It could be somebody, a third party. It could be anybody of the university's choosing, as long as that person doesn't have any stake or bias or conflict in the matter. And again, that's limited to, unless the parties actually select that person as their advisor, the university provided advisors are limited to just cross-examination. And again, another thing that's now explicitly required is not necessarily something overly new, but it is now formalized in writing, is the requirement that upon request, both parties receive copies of either the audio or visual recording of the hearing. Universities don't have to do both a video and, well, I guess if you have video, you have audio, but they don't have to do a video recording. They could just do audio, but whichever one they choose to do, upon request, copies of it must be provided to the parties. Go to the next slide, and we'll talk very quick about a couple of the post-hearing things that are now required under the final rule. So again, most universities have already been providing some sort of written report, but now just with the notice that must be sent out by the university before a hearing, there's very specific requirements of what needs to be in that written report. So again, this is something that ideally universities have been working on, to have some form of a template so that they can just plug and chug as they go, and make sure that they're including all of the relevant pieces. But again, make sure that you go back and actually check and see what needs to be included in those written reports, because it is pretty extensive. And finally, both parties have the right to appeal. And this is where it might be a little extra controversial, because obviously if an accused student is found responsible, he or she has a right to appeal. But now under the final rule, it does seem that if, let's say, a complainant is unsatisfied with a finding of non-responsibility, the complainant also has the right to appeal that decision. So it kind of would put the accused student through the ringer again. And the grounds for appeals, there are some that all universities must offer as potential grounds for appeals to students or employees, but there also is the option for universities to add additional grounds for appeals. And just like I said before, with either the burden of proof or where they have to apply it consistently. So if they allow employees additional grounds for appeal, they also have to allow students the same additional grounds for appeal, and vice versa. And so I think that's all we've got for the major procedural changes. Again, there's a lot to talk about, but if there are more specific questions, we can get into that. But I think Sean will clarify some stuff here too.
Yeah, thanks. If you could just change the slide. Great. So this is just a couple of slides with a handful of questions that came up as we looked at these new regulations and how they might impact sort of our life here in the Greek letter community. And one of the things we noticed, as Alana mentioned, was that there has been a change in how the Title IX cases are going to be sort of tried, for lack of a better word. It's obviously a lot more beneficial to those who are accused. I mean, it's a lot different from the process that we had under Title IX previously. So the question was, will Greek life conduct issues sort of come under this more robust Title IX process? And so in other words, will Greek letter members and organizations get some of these same sort of due process protections that we see coming up in the Title IX regulatory scheme? And upon review, it looks like probably not. It looks like what we're going to end up with is pretty much what we have today, which is two distinct systems. We're going to have a Title IX system, and we're going to have a student conduct system. And the relative protections for those involved in those systems could be very different, and likely will be very different. And the Title IX regimen or regulatory due process scheme is set forth in the regs. I mean, that's what's going to happen, as Alana just went through. On the student conduct side, there's been no such change. So I think on the student conduct side, we're going to see adjudications that are very similar to what we see today. One thought that I had was, well, could a university looking at sort of the dichotomy between these systems. On the one hand, a robust due process versus something less robust on the student conduct side. Could a university decide, you know what, even though this is the kind of a complaint that would veer into sexual harassment or sexual assault, we're going to go ahead and adjudicate this under the student conduct process? Because obviously a sexual assault or sexual harassment, yes, it's a violation of Title IX, but it's also a violation of the university or college code of conduct. That seems pretty clear. In the regulations, there is some pretty strong language that will funnel all cases that touch on a Title IX issue into the Title IX process, where those enhanced due process protections will be found. So, I think it's going to be a very sort of strict wall between these kinds of cases, and again, a very strict wall between the types of due process protections an accused person might expect. The second sort of item we looked at was how do the new mandatory reporter regulations work? And as Alana alluded to, the new regulations are in some ways a lot easier to deal with. Previously, I would say almost every single university or college employee would be deemed a mandatory reporter. It's probably not entirely true. There's probably some positions that wouldn't fit the standard of a responsible employee, but many positions would, and that would include professors, coaches, and of interest, sort of residential life advisors. So people that our members would interact with often in the Office of Greek Life, potentially, even residential house directors. So it was very broad under the old standard. What this regulation does is it sort of does away with the idea of mandatory reporters. So the universe of mandatory reporters under the law is very much smaller than it was pre-amendment. However, the regulations allow colleges and universities to identify reporters sort of at their discretion. So what's happened in practice, as we see over the summer, and is that the universe of mandatory reporters hasn't changed much. It's now a campus by campus evaluation to see what employees or what people the college has identified as mandatory reporters. But despite the change in the amendment, and given what's happened over the summer, the universe of mandatory reporters, as far as we're concerned, is going to look very, very similar. So, although a big change in the regulation, not a big change in practice and what's happening. You can change the slide. And Mike, I think, did you want to talk about the offsite question?
Sure. So that slide that I focused on earlier about events off campus, not at the house owned or controlled by the Greek organization, I think that is going to be something that is continually up for question once schools resume and once in-person events are able to safely be conducted. As far as this, we're at an off-campus bar, or a number of our members are out together independent. It's not an event organized by the group. Those types of things, I think schools will probably come to different conclusions of how to interpret that text that we went through earlier of whether or not the Title IX process applies, or if that's just considered kind of off-campus, not part of the educational program and not part of Title IX. The same is true of kind of these unofficial annex houses that have members of a fraternity or a sorority living in them that have events, but they're not owned or controlled by the fraternity or sorority. Schools kind of already varied pretty widely in how they treat those houses, and if they try to take the position that those houses are officially part of the group operations or not. But whether or not Title IX applies and what kind of decision the schools take, I think we'll see a pretty wide variation. I think it will be challenged quite a bit based on the facts in each campus and each facility, and I think that's going to be a major gray area with lots of challenges moving forward. And we can go to the next slide now. So we've generally kind of wondered what will this look like on campus today, and I know probably everyone on this call has, aside from Title IX, just been wondering what college campuses are going to look like here in the coming weeks and coming months. Generally speaking, schools have, the federal government was criticized for announcing this in May, saying it has to be in place in August amidst all the other chaos going on in our world today. And their position generally was, look, we've telegraphed that these are coming for quite a while. We posted relatively similar versions for notice and comment months before this. Schools have had time and they need to be ready for this. From various folks we've talked to at institutions of higher education, I think a lot are doing their best to say we're ready to go in the next 2 days when it becomes in full force and effect. As far as how ready to go they really are, I don't know. We'll see. There's been a lot of balls to juggle this summer in addition to trying to solve this. And anything new, any major change on college campuses can take a while. So I think schools would say they're doing their best and they're ready and working to comply. I also would have a hard time believing that this is going to be kind of smooth sailing once school begins. I think it's going to take a lot of institutions quite a while to really adjust to this. Sean or Lana, do you want to add anything on that?
Yeah, I think you're exactly right. I think from what I understand from talking to people in higher ed, they are doing their level best to comply with this regulation and not blow through the August 14th deadline. I had thought that there would be some schools that may say, you know what, we just can't do it, and whatever the punishment is, we'll deal with it. But that doesn't seem to be the case. And I think to some degree, because there is discretion, within the regulation. So for instance, on mandatory reporters, yes, there's no longer this sort of universe of mandatory reporters, but you can, at your discretion, identify whoever you want. Well, basically that just allows the university to do exactly what they've been doing for the previous, 20 years. And so I think that just for that reason alone, because it's easy and it's seamless, the university is going to operate, as usual. The one area that's going to be difficult for them, and I agree that it's going to be rocky, and I don't think it's going to go particularly well, is the implementation of all of the due process protections Alana talked about. That is a heavy burden, and to do it right, I think will take some time, and we'll probably have some bumps in the road here pretty shortly. Lana, anything to add to that?
Well, I think too, with just some campuses having hybrid classes, I'm not meeting in person at all. It's going to be really, like, if somebody asks for accommodations, what are those going to look like nowadays? I think there's just going to be a lot of unknowns that can't be predicted until the universities run into the issues, and then they're like, oh, maybe we need to revise whatever we came up with before. And that kind of, those revisions, though necessary, kind of go against the spirit of having a pre-made list of here are your options, and if you need supportive measures, here are the options of a possible sanction or possible remedy. If you're going back and revising them under the circumstances, that's great, but it also kind of goes against the whole spirit of having these in writing so people are aware before anything happens. So it'll definitely be interesting to see how universities handle that. I think everybody's gonna have to be a little flexible and understanding, especially I would say at least the first year or two that these are in effect.
We can go to the next slide now.
Yeah, so this is less nuts and bolts. This is sort of more about, sort of Title IX and what it does. Title IX is a statute that basically prohibits discrimination based on sex within our educational institutions. Over the summer, a case, which I got the title here, Bostock v. Clayton County, came out in, I think it was June. And it's not a Title IX case, it's a Title VII case. But Title VII is a very similar statute in that it prohibits sex discrimination within the workplace. So you get a case under Title VII, it has a lot of applicability to Title IX. And what this case did was it settled sort of a long-standing, simmering dispute about whether the law, Title VII, whether the law protected gay, lesbian, transgender people from discrimination in the workplace. And if you could flip to the next slide for me. And the court in this case, and I just keep hitting the next slide. I've got these on bullet points. There's 3 of them. The court in this case decided that yes, Title VII does protect gay, lesbian, and transgender people from discrimination in the workplace. And I just pulled out some quotes from the case because I think they bear directly on some of the things that we've seen at the university and college level when it comes to trying to regulate Greek life. And what the Supreme Court said here is that an employer violates Title VII when it fires a person based in part on sex. So in other words, there could be other reasons for the termination or the discrimination, but once you make a decision based on sex, you violated Title VII. And similarly, and very importantly for our world, the court made it very clear that it doesn't matter if the employer treated women and men equally. So what was at issue in this case was that, for instance, someone would bring their wife to an event. In one case, that person was a man, and in another case, that employee was a woman. Well, the woman who brought her wife to the event would get fired. So the only determining factor in treating the man and woman differently was based on that woman's sex. So, a man can do something a woman can't, which is bring a wife to a corporate event. So it was a very interesting case. It greatly extended protections to a whole group of people who desperately needed them. And it really does give us something to talk about within the Title IX arena. If you could flip the next slide, please. This just sort of more succinctly and in a way that uses an example makes the court's point. You basically, what the court is saying here is you cannot make determinations based on someone's sex. Now, at the time this case came out, the Harvard case was pending, and many of you will recall that Harvard adopted a policy that basically said, if you join a single-sex student organization as a student, then you will not be permitted to participate in a variety of leadership structures, such as team captainships, scholarships, Rhodes scholarships, things like that. That was a big problem at Harvard, where you have very motivated students who want to do all of that leadership activity. And you can say what you want, but this policy that Harvard implemented was aimed at men's finals clubs and men's fraternities. I am sure what Harvard decided in consultation with legal counsel is we cannot simply, go after the men's groups. If we want to undertake a policy like this, we're going to have to make it apply equally to men's groups and women's groups. And I think at that point in time, that was good advice. I think that's what many of us in the legal community felt, was that, if you had a policy that treated men and women equally, then that was very likely lawful under Title IX and in the employment context under Title VII. So several fraternities sued Harvard over this policy, and those fraternities in their legal arguments made the same exact legal arguments that's at issue in Bostock, which is that when you enforce a policy against a single-sex organization, you are inherently making a determination based on sex. And that was a novel theory at that time when Harvard was filed. And what the Supreme Court just did in the Bostock case is sustain that line of thinking. And it basically told the fraternities that they were right in their Title IX cases. Interestingly, shortly after Bostock came out, I want to say within a month or so, Harvard reversed course and withdrew its policy. So This Bostock case, well, again, not in the Title IX arena, it's in the Title VII arena. I think it has direct application to what we sort of deal with in the Greek world pretty regularly. So that was a very interesting development in Title IX over the summer, although not directly related to these new regulations. So next slide, please. Okay. I'll just, since I kind of have the mic right now, I'll just sort of explain what this is. We have been extremely busy over the summer getting ready for this fall term. It's been remarkable. And what we did is, even though this is about Title IX, we also went and put our heads together and came up with sort of 5 questions that we're getting repeatedly from our Greek letter clients. And so we thought we might talk about these for a little bit, or alternatively, we can move into more of a Q&A. And Katie, I don't know if you can see the chat or not, or see if there's any questions, or what your thoughts are on how to proceed from here. But this is the end of our Title IX material.
Sean, I can go ahead and check those questions. I will need to unshare my screen real quick, so I'll go ahead and check on that. It looks like we do have a few questions. Okay. Can an accused student represent themselves? Can they elect to not have an advisor in the process and then cross-examine a reporting party?
I'll take this one. So the accused student absolutely can represent him or herself. There's nothing that prohibits that. However, that student cannot also ask any cross-examination type of questions of either the accuser or any witnesses, himself or herself. That would have to be done through an advisor. Again, that's where it would come in that the university then has the obligation to basically provide free of charge a temporary advisor who will then do the actual cross-examination on that individual's behalf during the hearing.
Okay. Sean or Micah, anything you'd like to add?
No, I don't think so.
Okay. One more question. Is there any reference to organizations who have suspended and are unrecognized? What will be the relationship, liability, and responsibility of the university of the behaviors of those in these facilities?
That's a good question. There is not something that discusses unrecognized groups. However, the text we talked about earlier specifically applies to recognized groups. So to the extent unrecognized groups exist, the provisions that only applied to recognized groups would not apply to them. Generally speaking, I think that means that if an unrecognized group has an event and there's a potential Title IX violation at the facility of an unrecognized group, it's an off-campus private facility and it's not owned or controlled by a recognized group. So Title IX would likely not apply to any type of incident or report that took place at that type of event or facility.
Yeah. And, interestingly, that could be, a situation where the student conduct process may sort of trump what the Title IX process provides. Because if it's not a Title IX violation because it's off campus, then the Title IX due process requirements in that whole hearing process don't occur. But it is still very likely a violation of the student conduct policy. So you could have a situation there where this kind of a claim or this kind of an accusation could sort of wind its way into a student conduct process.
Okay, it looks like that's all, that covers all the questions we have for Title IX. So I will go ahead and hop back into the presentation here. I know someone in the chat feature asked if we could go into a little bit more depth on number 4 and number 5 on these hot topics, if there's anything additional you guys are able to add to it.
Yeah, I'll take 4, and then Mike, if you could do 5. Let me start with 4. Many campuses are trying or advising or, at least recommending that Greek chapter houses provide some kind of quarantine area or quarantine room or something like that. And ideally, that's a single with its own bathroom. But we all know that that isn't possible in many places. To the extent it is, I think groups are doing that, but it's just not possible in many different chapter houses. So ideally, in the kind of chapter houses where we can't quarantine someone safely, or even if we have multiple members that are ill and we can't quarantine all of them, ideally we would like those members to leave. That would be, I think the choice of most groups. It's a very sticky situation to have, because if somebody voluntarily leaves, then great, fine. They have somewhere to go. They're going to go to a hotel. They're going to go see their parents, or they're going to go to the university and stay in a quarantine dorm on the university campus. But when you have a member who says, look, this is my house. I'm basically paying rent. You can call it a housing agreement or whatever, but it's rent for leased premises, and I'm staying. The law is not really going to help us here, because for a couple of different reasons. First of all, it's not at all clear that member is wrong. There's most likely nothing in our leases that say you must leave if you get sick. That's not something that is, found in most leases, that you would have to leave your own rented home because you're sick. So, it's not immediately clear that would be like an event of default or anything like that under a lease agreement. And even if it were, and this is really the more realistic problem, is even if there were some event of default here, the courts are not going to hear your eviction case in time to help you. It's not going to make it through the courts in time. And even if it made it to court, I doubt a judge would actually allow you to evict someone who is ill. So there is no legal solution to this problem. What we've been, and because there's no legal solution, there's likewise no contractual solution. I mean, we could write contracts and say, yeah, it's an event of default if I get sick and I don't leave, or, I covenant and agree that I will leave if I become sick. But again, you can't enforce it. So what difference does it really make? What can help, and what we have seen, seem to have some benefit, is creating some sort of agreement within the brotherhood or the sisterhood that, this is an illness, it's a pandemic, it's all around us, we're in this together, and we're going to support our brothers, or we're going to support our sisters. And we want, our brothers and sisters to be safe. And in order to make that happen, we will all agree, all those that live with us in the house will agree, to the following list of rules, or whatever, conditions, whatever you want to call it. But one of them could be, if I become ill, I will leave. That would engage, some pretty significant pressure from the group to do what is right, and to do what you actually agreed to do when you moved into this room, which was move out if you became ill. But short of encouraging or cajoling or pressuring this kind of voluntary compliance, there's very little a house corporation can do in this situation, unfortunately. You could always adopt a rule, and we've seen that too. So you adopt a rule and regulation of the house corporation that says you must leave. And if the member were to fail to honor that obligation, you could seek membership discipline within the organization, and that may be appropriate, maybe not. It's kind of an individualized determination, but the legal system isn't going to be there on this one.
So I'll take the last one. What is this Abolish Greek life thing? I'm sure many or most of you are familiar with it and have been dealing with it lately. Kind of in this wave of activism in the last few months, there has been I think a relatively small but somewhat well organized movement on some college campuses seeking to persuade the campus and to persuade the Greek organizations themselves, or the members of Greek organizations themselves, to kind of close up shop, to cancel themselves on the grounds or on the notion that the fraternity and sorority system perpetuates inequality or was built on inequality, and that the campus or life generally would be better without them. Most people who have really taken a look at this have felt like it's been a relatively small group of folks that are doing this. It is usually the pressure, the kind of formation of the call to action is done anonymously and not in a way that's easily traceable to a specific individual or individuals. But in a few places, it has resulted in some serious action and members resigning, or in even a couple of instances, I think entire chapters essentially deciding to close up shop. So it's certainly gotten folks' attention, and a lot of people have wondered, what are we able to do? What aren't we able to do? And I think there's, from kind of a law and a practicality standpoint, a couple different ways to look at it. From a practicality standpoint, I think a lot of people are debating, do you want to push back against some of the claims that seem unfair or inaccurate and explain, why they're inaccurate or unfair, knowing the challenges of trying to respond to an anonymous, person raising this concern. So that's been one thing people have wrestled with, and I think many feel that this will likely kind of move on and dissipate as campus returns, and there are certainly other large issues people are working to tackle. Some folks have specifically wondered about, reporting these things as inaccurate, as harassing, as an unauthorized use of your organization's marks. And I think depending on the media through which these things are disseminated, you can report them to Twitter, to Facebook as potential violations of the terms of use, of unauthorized use of your intellectual property, each of those types of things. So that can be done. Whether or not that's yielded any real meaningful success, haven't really heard of many clear examples of that yet. And some of these are, random WordPress websites where it's even harder to do that. So, this is a challenge. Our First Amendment allows people to put things out there and put their views out and put it out anonymously if they choose. And it's very hard to really be able to respond other than to just kind of make your own argument for the value or what these people are missing or don't quite understand. But it's certainly something in the last few weeks, there's been a lot of talk and discussion about it. And it's not really quite clear how that will continue to play out, but definitely something we'll be keeping an eye out for the fall, and happy to talk with any of you or your groups about as it continues to come up and potentially impact your groups. So I think we're about out of time now. We do
have one more question though, if you guys think you'll be able to get to it, if that's okay.
Sure.
Does the advisor representation have to be the on-campus advisor, or can it be the organization appointed advisor?
I'm assuming that question's about the advisor for the Title IX, like during the hearing and stuff. Is that what?
That is correct, yes.
So that advisor, again, there's a distinction between the organization as a whole and individuals. Usually the Title IX allegations of sexual harassment or sexual assault, it's going to be brought against just an individual. And it's the advisor can literally be pretty much anybody, as long as, like, obviously a student, the parent of the accuser, or representing him or her as the advisor. So it's up to the individual parties of who their advisor is going to be. They cannot force somebody to be their advisor, but it could be the on-campus advisor if they have a very good relationship and that feels to be the most appropriate, but it certainly doesn't have to be that person. It's not limited in any way.
Okay. Well, thank you everybody for your time today. Thank you for being in attendance of today's presentation. Huge thank you to Fraternal Law for going over this very pressing topic. So thank you for your time and getting this all together. As we said in the beginning, the session is being recorded, so I will send out a link to everyone to download the recording if they need it. We'll also include a copy of the PowerPoint as well as the email addresses for all 3 of our presenters again. We will also be sending a doodle poll just to see if there's any interest out there in having a true roundtable. In the beginning, that's kind of how this started. But since COVID, we've been able to open it up to a larger audience. But just want to get that out there, see if there's something we can get going with that. But with that, I will go ahead and let everybody go. And I hope everybody has a great day. Thank you.
Thank you.